Welcome to Legal Lines. My name is Tom O'Shea, the host of this program brought to you by the York County Bar Foundation. My guest today is attorney Brent Difenderfer. Brent is an attorney with CGA Law Firm, and our topic today is bankruptcy law. Brent does many bankruptcy cases, and that's the topic that we have. So let's start out with the very first basic question. What is bankruptcy?
Bankruptcy is prescribed by the U.S. Constitution and by federal law, and the purpose of bankruptcy is to provide people with a fresh start. People that have lost their job, are facing home foreclosure, having problems paying bills. These are the type of people that are seeking relief under the Bankruptcy Code.
Okay, go ahead.
The types of debts that are discharged in a bankruptcy, discharge meaning that the person who is declared bankruptcy is no longer legally required to pay them, would be past due bills, credit cards, personal loans, medical bills, things of that nature.
Right, so the first thing that you pointed out is that bankruptcy is something that is actually in the United States Constitution.
That's correct.
It's sort of a right. It's not part of the Bill of Rights, but it's within the Constitution that the court should establish a system for bankruptcy.
That's correct. It's in Article 1, and it's in Title 11 of the United States Code.
Okay. And then the bankruptcy courts are actually federal courts.
That's correct.
And there's a statute in the United States Code that then deals with the bankruptcy laws.
That's correct. It's all in Title 11, and also the Federal Rules of Bankruptcy Procedure govern how the bankruptcy process works, who is entitled to seek relief, the process by which the courts administer the system.
Okay, so when we hear that someone is filing for bankruptcy, the general idea I think that most of the public would believe is that allows somebody who has a debt to either not pay the debt or not pay all of the debt. Is that a simplistic way of looking at it?
It ultimately depends on who has declared bankruptcy and what type of bankruptcy has been declared. Bankruptcy is available for individuals and also for business entities such as corporations and other business affiliations. A person who is an individual is entitled to seek relief under either Chapter 7, Chapter 13, and then under limited circumstances, Chapter 11. Most cases that I'm involved with are either Chapter 7 or Chapter 13.
Okay, and people who talk about bankruptcy cases, you'll frequently hear them mention chapters. I take it those are the chapters that are under the Bankruptcy Code.
That's correct.
Okay, and Chapter 7 is for individuals?
It can be for individuals, but also for businesses that would be stopping business activity and are looking to just shut their doors. But it is also available for individuals, and is the most common bankruptcy for individuals.
Right. And the other common one is Chapter 13.
That's correct. Chapter 13 is available for individuals who are above median income according to the census, and also for individuals who are looking to achieve some sort of strategic goal, such as saving a home from foreclosure, saving a vehicle from repossession, or perhaps paying back certain non-dischargeable taxes, such as to the IRS, Department of Revenue, or the local taxing authorities, real estate taxes, things of that nature.
But if now I'm looking at this, I don't handle any bankruptcy cases, as you may know. But simplistically, if a Chapter 7 is what I've always heard is called a liquidation bankruptcy, whereas a Chapter 13 is a reorganization bankruptcy. Are those terms accurate?
Yeah, that's correct. Chapter 7 typically lasts maybe about three to 4 months, and the general idea is that you're seeking a discharge for all your debts, and all your personal property will be liquidated. That sounds actually more scary than it really is, because there are very generous exemptions that are available for an individual debtor. And typically, an individual debtor will not have to give up any personal property so long as they do not have personal property that is worth a lot of money. For instance, if you have a 10-year-old car that's only worth $3,000 to $4,000, that's a type of vehicle that you can keep. However, if you just bought a Mercedes for $20,000 and that vehicle is owned free and clear of any liens, that's the type of property that you might have to give up in a Chapter 7.
Okay, and that would then, any money that came from the liquidation of those assets would be used to pay the creditors some of what was owed.
That's correct.
And in a Chapter 13, a reorganization, what's the general premise there?
Well, people that are going into Chapter 13 may be required to go into a Chapter 13 because they earn income above certain income levels. For instance, the average family size of two in Pennsylvania makes about $51,000, $52,000 according to the census. So if the individual earns more than that limit, they are probably going to be required to go into Chapter 13 and pay something back to creditors. The idea being those who can afford to pay something, maybe not all, of their debts should do so. That the amount of money that is paid in a Chapter 13 will be calculated by something called the means test. The means test is a mathematical calculation described in the Bankruptcy Code where we determine how much, if any, you should have to pay back to your creditors.
Okay, now, if again, I'm looking at this simplistically. If we're dealing with the Chapter 7 bankruptcy, ultimately the person will be told there are various debts, mainly credit card debt, that you no longer have to pay back at all.
That's correct. The general rule is that all debts are going to be discharged in bankruptcy, although there are several important exceptions. For instance, student loans are generally not discharged in bankruptcy unless there's a case of severe hardship to the debtor. Any sort of debt that is a result of fraud or embezzlement or criminal activity is, of course, not going to be discharged. Court costs, criminal restitution are also items that are going to be not discharged. And as a general rule, taxes are going to be non-dischargeable as well, although there are some circumstances where taxes, if they're old enough and the debtor has filed all required tax returns, in limited circumstances you can discharge taxes as well.
Okay. I believe one of the other things that I know from family law is that obligations for past due child support or alimony cannot be discharged.
That's correct as well.
Okay, and when we say that it cannot be discharged, that means if you have, let's say, a student loan that you owe $25,000 on, you go to bankruptcy court, you still owe that $25,000 even if your credit cards have been brought down to not owing anything.
That's correct. It's specifically stated in the Bankruptcy Code that these types of debts, as a general rule for societal purposes, should be deemed non-dischargeable.
Okay, so in a Chapter 7, basically the idea is that the individual who goes through a Chapter 7 has a clean slate to start life over.
That's correct.
Economically.
That's correct. In fact, the United States Supreme Court has said that the purpose of bankruptcy is to give the honest but unfortunate debtor a fresh start. And that's what the ultimate purpose of filing for bankruptcy is, to get all the debt behind them, give the person a chance to start over again and to start rebuilding their credit.
Whereas with respect to the Chapter 13, the reorganization type bankruptcy, there the person going through the bankruptcy has to pay some of the debt back under a payment plan. Is that correct?
That's correct. Each chapter does provide for a discharge. In a Chapter 7, like I said, it takes about 3 months for that process to go through. About 3 months after a person files for Chapter 7 bankruptcy, they are legally discharged. A Chapter 13 bankruptcy, the person enters into a payment plan that lasts anywhere from 3 to 5 years, and whatever is paid into the bankruptcy is paid to creditors, and whatever remains unpaid to creditors is discharged. For instance, if the debtor owes $50,000 of debt and pays $25,000 to creditors over the course of 5 years, the remaining $25,000 that was unpaid will be discharged in the same way as it would have been discharged in Chapter 7. It just happens at a later date upon completion of the Chapter 13 plan.
But I think you also mentioned that there's some type of income test to determine whether or not somebody qualifies for a Chapter 7 versus a Chapter 13.
That's correct.
Now, you mentioned something about median family income. How does that fit into this income test?
Well, that's the threshold question, is whether or not you are above or below the median income level. We actually look at the census data to determine what the income level is, and if you are above that limit, then we have to take this means test, which is a calculation that the bankruptcy code describes how much you can afford to pay back to creditors on a monthly basis.
Approximately how much family income is the dividing line between a Chapter 7 and a Chapter 13?
Well, for instance, a family size of 2 makes approximately $51,000, $52,000 a year.
So if somebody made less than $51,000 a year, a family of 2, they'd easily qualify for a Chapter 7.
They're likely to qualify for a Chapter 7. There are some situations where you may still be required to go into a Chapter 7. Those are limited circumstances that are probably beyond the scope of our talk today. Okay. But as a general rule, that person would qualify for a 7 unless they wanted to be in a Chapter 13. And there's good reasons for being in a Chapter 13. For instance, if your home is up for foreclosure and you need to stop a sheriff's sale, a bankruptcy filing will stop the sheriff's sale and provide you with an opportunity to pay back the money that is in arrears to the mortgage company over the course of 5 years. So Chapter 13 is actually a very powerful and popular way to save the family house.
Okay, but with a Chapter 13, if somebody has a higher income than the median, let's say somebody has an income of $75,000 and for 2 people in the household, that person most likely would wind up in a Chapter 13 even if they would prefer a Chapter 7.
That's correct. If that person in those set of facts would try to file a Chapter 7, the United States Trustee's Office, who is sort of the referee in the whole process, they're part of the Department of Justice, would object to the filing as abusive and file a motion with the bankruptcy court to force the debtor to convert to Chapter 13.
So if I may summarize, as I understand it, the theory is that people with higher income should be responsible to pay some of the debt back rather than just discharging it and having a clean slate like someone who has less income.
That's generally true. People who have higher incomes also tend to have higher expenses, though, as well. For instance, the person who makes $75,000 a year may pay $2,200 on his or her mortgage payment. In the means test calculation, the mathematical formula that determines how much you can afford to pay back to your creditors will take such expenses such as mortgage payments and car payments into consideration as far as how much you can afford to pay. So
this isn't like a flat dividing line of $45,000 income or less. Your Chapter 7, Chapter 13, there's somewhere in between where they'll look at your actual expenses for certain items and maybe adjust the income so that someone may qualify for a Chapter 7 even if they're above the median income.
Somebody who is under the median income levels does not have to really take the test at all.
I'm going to stop you right here, and we're going to talk about this when we come back. We're just about ready to take a break. This is Legal Lines. My guest is Brent Difenderfer, and we're talking about bankruptcy. Welcome back to Legal Lines. My name is Tom O'Shea, the host of this program, and my guest today is Brent Difenderfer, an attorney with CGA Law Firm, and our topic is bankruptcy law. And before the break, we were talking about the differences between Chapter 7 bankruptcy, Chapter 13 bankruptcy. But one thing that I forgot to talk about before is before you can file for bankruptcy, you need some type of credit counseling under the law. Is that correct?
That's correct. That was part of the 2005 changes to the bankruptcy law. And every person who declares bankruptcy, before they do that, they have to seek a credit counseling through a accredited credit counseling agency that is approved by the United States Department of Justice.
So it has to be a program approved by the United States Department of Justice. If somebody wants to know whether a program is approved by the department, how would they check that out?
Well, it should be directly on the literature that is being distributed to the person who is considering bankruptcy. It's usually on the websites. Usually it is on the materials distributed to them, and it's not hard to find that out.
Okay, and if they would go on the Justice Department website?
If somebody wants to have a list of credit counseling agencies to use, then there's a website through the Department of Justice that you can check to see which credit counseling agencies are accredited.
Right. So before an individual would file a bankruptcy, they must go through this program. Is it a class?
It's a class that lasts about an hour. It can be done over the phone. It can be done over the internet. It's not a difficult class. Some people learn something from it. Many people do not learn something from it. But it is a requirement that everybody has to take the class.
And to make sure you're taking a certified class, you need to make certain that it's one that's approved. When I have the radio on, I'll hear advertisements about some type of debt consolidation, debt counseling, etc. That doesn't necessarily meet the qualifications of the bankruptcy court as an approved agency.
That's correct. You need to be careful about the distinction between a credit counseling that you need to take for a bankruptcy class and from a debt consolidation program, which is what you're referring to. Many debt consolidation programs do advertise on TV, on the radio, and that's something different. Those types of programs are looking to either consolidate or negotiate settlements for various debts and to act as a middleman to pay the debts incrementally. And that's something that lasts a long time. Over time, the credit counseling that you need to take before you declare bankruptcy takes about an hour.
Okay. And you basically cannot file the paperwork with the court until you have some type of proof that you took such a class.
That's correct. There is a provision that says if exigent or emergency circumstances exist and the debtor does not have access to a credit counseling agency, then there is some paperwork that can be filed with the court to get around that requirement. But you do need to have emergency circumstances to justify that. And many of these credit counseling agencies do have very flexible hours, and it can be done online and over the phone. So practically speaking, none of my clients have ever had the need to file bankruptcy before the class is taken.
Okay. Now, with respect to bankruptcy, one of the issues that is, with the economy the way it is today and with people receiving those pink slips and unemployment being what it is people sometimes cannot afford the mortgage on their home.
That's correct.
And how does bankruptcy play into mortgage foreclosure?
Well, mortgage foreclosure, of course, is a real problem in the country. Many of the bankruptcy clients that I see are coming to me first for help with regard to a mortgage foreclosure action. Perhaps they've tried a loan modification with their bank. Maybe they were not successful in getting a modification and their home is still up for a sheriff's sale. A Chapter 13 bankruptcy or Chapter 7 will stay a sheriff's sale.
Now, when you say stay a sheriff's sale, what does that mean?
That means that the sheriff's sale legally must stop.
Right. So if the house is up for sheriff's sale because the mortgage hasn't been paid, the lender, the bank went through the process of foreclosing on the house, and there's some sheriff's sale that's going to be scheduled next week. If I file for bankruptcy today, can the sheriff's sale take place next week?
Probably not. There is a process by which the bank can go into bankruptcy court to get relief from the automatic stay, and in 7 days' time, perhaps the bank might get permission, but generally speaking, a bankruptcy will stop the sheriff's sale. And typically, bankruptcies will be filed not 7 days before a sheriff's sale, but probably 2 to 3 days before, sometimes even the morning of a sheriff's sale.
That's just to prevent the bank from going to ask the bankruptcy court to lift the stay, right?
That's generally true.
Yeah. All right. So, but it can be done, and that would give the owner of the house more time to try to work out some arrangement to save the house.
In the Chapter 7, the homeowner would have to work by himself, independent of the bankruptcy, to work out a loan modification or some sort of alternative arrangement to pay back the mortgage arrears. In a Chapter 13, there is a process where you can propose a payment plan on your mortgage arrears. For instance, if you're $60,000 behind on your mortgage, you can propose to pay all of your mortgage arrears back over the course of a 60-month payment plan, 60 months in a 5-year plan, in which case your payment will be about $1,000 a month to the Chapter 13 trustee. And that gets you caught up on your mortgage payments. And that is something that, as long as your Chapter 13 plan meets the confirmation criteria that the Bankruptcy Code prescribes, then there is nothing that the mortgage company can do to sell the house while you're making payments to the Chapter 13 trustee. So it's a great tool to save the house, and I've saved dozens of houses that way in Chapter 13.
So although it can save the house, one thing you need to stress is the person who owns the house still has to come up with a way to pay the mortgage.
Right. It will only work if you have the ability to pay your normal monthly mortgage payment and pay this additional trustee payment every month. So it's helpful in situations where perhaps somebody has lost a job or they've gotten sick at work, that they no longer have their income stream, but has since regained it. And they just don't have the $60,000 to write a check to the bank to get caught up. They need some time to work things out. So you do need to have a cash flow to get caught up on the mortgage.
Okay. Now, the other issue, even with the Chapter 7 bankruptcy, which I call a liquidation bankruptcy, people can keep certain assets even if they go through the bankruptcy and get their debts discharged.
That's correct. Exemptions are an important part of bankruptcy, and there is a list of 12 different categories of types of property that one can keep in a bankruptcy. For instance, you're allowed to have about $21,000 in residential equity in your primary residence. Equity is the ownership interest in property that you determine what the value of the property is and whatever mortgages or liens are against it.
So if I had a $100,000 house and owed $80,000 on my mortgage, I'd have $20,000 worth of equity.
That's correct.
That would put me under the $21,000 that I would be allowed to keep. So as long as I could keep paying my mortgage, I would be able to keep that house, go through the bankruptcy, and discharge my credit card debt, for example.
That's correct. And there's other exemptions as well in addition.
But let me talk a little bit more about the house. If a husband and wife go bankrupt together, is that capped, and they own the house together, does that $21,000 grow to $42,000?
It does, actually.
So if in the same scenario, if I have that $100,000 house that is owned by a husband and wife jointly, and they go bankrupt jointly, they could have up to $60,000 equity, $58,000 equity in that house, and be able to, up to $42,000 equity in that house, and be able to keep it.
If we were using the federal exemption scheme, however, there's also in Pennsylvania you have the choice to elect the state exemption scheme, which says that any property that is owned jointly as husband and wife is exempt to the extent that there's only one creditor against either spouse. So potentially you could have more equity than $40,000. But that's a kind of a limited set of facts that I see every once in a while. But generally, if we're using the federal rules, each spouse can claim $21,000. These numbers change every year depending on what the statistics are reported to the Department of Justice. So this year it's around $21,000, $22,000.
Now, what about other assets that people can keep even if they go through a bankruptcy? We talked about the house. What about vehicles? They need transportation to get to work.
There's a $3,500 exemption for one motor vehicle. If it's a joint filing, then it becomes two motor vehicles, each with a $3,500 exemption. Again, this is equity, not a value, so we have to determine what the car is worth first, and then we subtract whatever lien is against it. So if there's a vehicle that's worth $13,500 and there's a $10,000 loan against it, that's going to be exempt in the bankruptcy.
So long as the person makes a plan to continue to pay that car loan.
That's correct.
It doesn't get them out of the car loan.
Right. It does not discharge the car loan. The lien that is on the vehicle is a property interest that belongs to the creditor, and the person who has declared bankruptcy will have to continue making the monthly payments.
Now, is that $3,500 for the car in addition to the $21,000 for the house?
That's correct. These are the exemptions for the property on the house and the vehicle are two separate exemptions. Although there is a concept called spillover that, to the extent you do not use all of your residential real estate exemption, you can bring some of that over and use it for other categories of property. So it's possible that you may be able to exempt more value in other categories that you spill over into.
Okay, can you tell us some of the other categories?
Oh, there's a personal property exemption.
Now, personal property basically means furniture?
Furniture, pots and pans, things that people have in their house.
It's unless somebody has something of extreme value, the bankruptcy court isn't going to come in and take a person's furniture or pots and pans or towels or anything that people need to live.
There's about a $10,000 exemption for personal property in one's house, and we actually use a garage sale or Salvation Army type valuation. It's not what would a brand new piece of property cost. It's what you'd expect to see your kitchen table, your sofa at a garage sale.
Okay. And then what about cash in the bank? Are you allowed to keep any after a bankruptcy?
Yes, and in fact we would use that spillover exemption that I was referring to earlier that's kind of tied in with your residential real estate exemption to exempt cash in a bank account.
Okay. All right, we have less than a minute left, but one of the things I've always heard people say about bankruptcy is that if you go bankrupt, it will ruin your credit forever. Can you briefly say whether that's true?
That's not true. In fact, many clients of mine have gone on to successful lives outside of bankruptcy, getting new car loans, getting mortgages. So it does not ruin your life forever.
And so this goes back to the general purpose of the bankruptcy, which is to give individuals who find themselves in a bad credit situation a fresh start.
That's right.
Which is something that the United States Constitution basically guarantees people, and Congress has put in place as to how it should be operated.
That's right.
Well, thank you, Brent. Today's program was on bankruptcy. My guest was Brent Difenderfer, and this is Legal Lines, brought to you by the York County Bar Foundation.